for us to get started, and I'd like to welcome our audience as well as welcome and thank our panelists for being present. Just a brief introduction. Each of these extremely accomplished lawyers have much longer bio, but I'd take the whole hour if I were going to actually tell you all about them. But alphabetically, let me start with Rob Ammons, who is a well-known lawyer from Houston. And thank you, Rob, for being with us today. He's been a super lawyer for almost 2 decades, and he typically represents policyholders in insurance claims, and he's been, in fact, lead counsel in over 350 claims, litigations, and so forth. But thank you, Rob, for being here. Rob is, in contrast to the other panelists, is went to Baylor Law School, and we like Baylor a lot, so welcome. Thomas Johnson is a Loyola grad and is a member of the firm Johnston Hutchinson Lira. He represents plaintiffs in wrongful death cases, a lot of plaintiffs in various kinds of cases, including insurance. Like Rob, he's a member of the American Board of Trial Advocates, or ABOTA. And one thing I just note about Rob is that he received the top motorcycle verdict in the entire United States in 2016. So that's quite an accomplishment, and has had a lot of other verdicts as well. Our third panelist, and someone who I'm particularly proud to introduce, Uyen Nguyen, or Gwen, I guess, is if you were in Saigon, would be perhaps more correctly pronounced. Several decades as a lawyer, has represented primarily insurers in policy disputes, in complex litigation, and has had multiple defense verdicts. Welcome, and thank you for being a part of this, Uyen. Finally, but last but not least, by any means, Bob Shapiro, senior name partner at Glaser Weil in Los Angeles, internationally renowned lawyer, representing all kinds of companies in both as plaintiffs and as defense. Does a lot of complex business litigation and has represented many famous personages, including O.J. Simpson, Christian Brando, a number of highly regarded and well-known business personages, and is also a famous Loyola alum. So thank you for being here as well, Bob. With that, I think I'm going to start with you, Bob, since we want to make sure that everybody understands what our topic is today, and it has to do with business interruption insurance. So let's start with the big question: what the heck is it?
So business interruption insurance is something that just about every business in America has, and that is to spend money on a premium to get coverage in the event that your business cannot continue as usual. There is now almost universally insurance companies claiming that even though people have spent millions and millions of dollars on premiums for business interruption insurance, that because of a virus, they are not going to be paying any claims, and they're denying them out of hand for 2 reasons. One, if there is a virus exclusion, they claim that the policy has no validity whatsoever. And that the reason that their business was interrupted is because of a virus. Our position is quite the contrary, that we don't have any clients who closed their hotels, their restaurants, their beauty salons, or other businesses because of the virus. They all closed for one reason. The government made them close, and in many cases continue to require them to be closed. The second element that is in all of the policies is a catch-all phrase, physical loss or damage, that has to be proven. And so the insurance companies are taking the position that this actually has to be something like an earthquake tearing down your building, or a tsunami coming and taking your building down the street. We take a totally different view of this, clearly, because you cannot have a greater physical loss or damage than your business being closed. So that's an overview of where we're at in fighting the insurance companies and pursuing claims for many businesses that have been wrongfully denied their coverage.
Well, let's, I know that there's been a recent lawsuit filed, a major litigation filed in California, and that Rob, I think you are involved in this litigation. Can you just tell our audience, what is this litigation about? What are you claiming? Who do you represent, and so forth? And who are you suing? Right?
Sure. Along with Bob and Thomas, we have filed a case on behalf of the Catch Restaurants. That is a restaurant chain, very prominent, for their business losses. They were shut down. They made a claim, and they were summarily denied by their insurance carrier. That's a case for a very significant restaurant. We've also have a class case that has been filed for one policy. Hartford, it's a class action. That policy actually has a virus inclusion, a sublimit for virus coverage, and claims under those policies have been denied as well. So both of those are pending in different courts in California.
Okay, so you represent insurers and have done a lot of cases involving interpretation of policies. Is this kind of a case purely a question of interpreting specific policies?
Yes, it is. So in the context of insurance and coverage, it's a matter of just basic contract law principles. What did the parties agree to, and what is the carriers willing to provide in terms of coverage for certain losses, and that correlates to what the underwriters have written in the policies and have generated a specific amount of premium. And so the premiums paid over the period of time for the policy should spread the risk of that loss.
So the way these policies work, and there may be members of the audience who are not quite as familiar with it, but you start off with a basic policy where you have a what's called coverage, and that defines the ambit of what could potentially be covered. And so far that's correct, right?
Yes.
And then you have a separate provision in the policy called exclusions, where these things are kept out. And you've heard both Bob and Rob talk about, the nature of the lawsuits and the claims. If you were representing an insurer in this kind of a problem, what would be the major things that you would be arguing?
Well, first of all, we would argue as a counsel for a carrier, I would argue that this is a contract between the insured and the carriers, and the contract provides for a list of certain things that are covered as a result of certain events, triggered events, and certain perils. And there's only coverage if there is property damage that arises out of a covered cause of loss. And typically in these types of commercial property insurance policies, there must be property damage. And that's defined as physical loss or damage to the insured's property.
Okay, sorry. Yeah, if you were talking about physical loss, you would, using Bob Shapiro's analogy, you would be looking for literal damage to a building. Is that what physical damage means in your understanding?
Yes, typically, traditionally, these types of policies cover certain triggering events such as a fire or a flood. So with a fire, you have physical damage and loss to the property. There's actual physical alteration to that property. And as a result of that, your business now might have to close down or is suspended in order to repair that damaged property.
Okay, thank you. Thomas, let me ask you kind of another broad question about the importance of the kind of litigation that you've been responsible so far for filing, and there may be others around the country. But how significant are these questions about business interruption, about the interpretation of these policies?
Well, I think it's critical, and I can tell you a little bit about it. Can you hear me okay?
Now we can, yes, thank you.
Okay, great. Well, Bob Shapiro, Rob, and I, we do cases together in LA and Houston, and we were talking, and what was interesting is we were getting so many calls from former clients that own businesses and general counsel who work for businesses about the same situation. And it covered a lot of different companies under a lot of different scenarios, but there was a common theme. And the common theme was these businesses had bought policies provided for business interruption coverage. In a lot of cases, it had a virus inclusion. And across the board, they were getting rejected from Houston and Los Angeles and all of California. And we started looking at it a little bit deeper, and we learned that it was happening all across the country. And so what is happening is the carriers have decided they will not pay business interruption coverage on COVID-19 claims. And they've taken that position. And what we decided was we have to do something about it because these businesses did everything right. They bought the right policies. They evaluated their risk appropriately. And then when they really needed them, these carriers have said no. And that's what these cases are about across the board.
Okay, so let's delve into each of the kinds of issues that are likely to arise in this. And Bob, I know you mentioned about the virus exclusion. Now, if I were an insurance company and I wanted to make sure that if people got sick because of the flu and your business shut down because, you know, all of your employees were out with the flu, I might decide I don't want to cover that particular situation. Isn't that a fair assessment by an insurance company? You know, it's not the flu, but COVID-19 and the risk of people getting sick and so forth and closing a lot of businesses down. Isn't that what's behind what caused the business to shut down?
No. We have interviewed every one of our clients, and we have probably about 50 that we're going to be pursuing in different states and in different venues. And I asked all of them the same question. When this virus was in China, did you close your restaurant or beauty salon? They said, no, of course not. So when this virus went to Europe and went to Spain, Italy, United Kingdom, and you were aware that this was spreading, did you close your business? No. When this virus came to New York and we saw everything that was taking place, did you close your business? No. Why did you close your business? Well, I live in Los Angeles, and I heard the governor and the mayor tell me that we are having a complete shutdown. We can no longer operate. We're out of business. That's the reason that we shut down our business. Otherwise, we'd be operating today.
In other words, in other words, the fact that the virus might have led the governor and the mayor to issue these orders is not the reason that is the virus isn't the reason they shut down, but rather they responded to the orders from government officials.
Absolutely. You know, for all the law students, it's a analysis of what is the proximate cause and what is the cause in fact. So when you look at it that way, the proximate cause of the businesses shutting down was not the virus. That was the cause in fact, but not the proximate cause. The proximate cause clearly was the government.
Okay. So I think Ewan, you might have a response to that since you represent insurers in a variety of capacities. How would you respond to that particular claim about proximate cause?
Well, as a representative of the carriers, I would probably state that if you wanted proximate cause and you wanted to provide coverage for this type of a pandemic or this type of risk, then you as the insured or through your broker should have requested this type of coverage. And then that would have been calculated in an underwritten policy to allow for that. And your premiums may be a little bit increased or significantly increased in order to cover that. But as it stands, there's policies now where those premiums that have been paid over the lifetime of the policies, they did not allocate the risk, and it did not take into account for these types of losses. And so therefore, the carriers do not have the funds, even though these premiums have been paid over a significant period of time, they just aren't adequate to now pay out the enormous claims, because every single business is suffering from these types of losses everywhere across the United States and in the world.
Okay, so just a quick interjection here. If you're just joining the conversation, we have 4 panelists talking about business interruption insurance, and there have been lawsuits filed in Los Angeles and Texas, and I think at this point several dozen other states have also seen litigation around these insurance policies. And essentially the claim is that businesses who had to shut down for one reason or another, the claim is that they have these business interruption insurance policies, and they want to claim coverage under them. And so far, as I understand the conversation that we are having here, insurers have been denying those claims. So let me ask Rob. We talked a moment ago about the interpretation of a particular policy. And so since you have dozens of insurers, presumably who issued many different kinds of policies, is this going to be a policy by policy, I mean an insurance policy by insurance policy decision?
Many of these, well, all of these insurance policies, I have not yet seen any that are not what we call all risk policies. Versus a named peril policy. A named peril policy would be, for example, for wind, if you, or earthquake, as someone had suggested. These, with an all risk policy, everything is covered unless it is excluded. That's the way this was supposed to work. Now, that's a generalization that extends to almost all of the policies. I've yet to see any that are worded differently. The exclusions can be worded somewhat differently. So there will be some specific analysis on a policy by policy basis. But to claim that you have to have brick and mortar or structural damage in order for there to be physical damage or loss is inaccurate. Courts have held that contamination, for example, is a physical loss. They've included the loss of use as being a physical loss. So these are all risk policies, and if they wanted to exclude this, they should have done so. If they wanted to claim that it was physical loss or damage meant tangible physical damage or destruction, they could have worded it that way. Instead, they left it broad. They did not define physical loss or damage. And that's true for all of the policies. So all of them are all risk policies. All of them have this same terminology, and none of them have defined it in the way that the insurance companies are now advocating for.
Have there been, and I'll throw this out to all of you, have there been interpretations of this particular all hazard policy, at least that particular provision, that would affect the interpretation down the road of the particular claims that are being filed following COVID-19?
John, absolutely. There are probably somewhere between 50 and 100 cases that around the country that interpret this language. There's a case, for example, in Oregon, the Oregon Shakespeare Festival Association. They held that smoke from a adjacent wildfire that would blow over into the theater was physical damage or loss. The original case is the Gregory packaging case. It was versus Travelers. In that case, they held that ammonia levels that were entering into the premises constituted a physical loss. None of this had to be cleaned like we have to clean up for COVID. None of this had to be remediated. All of it was considered to be physical loss or damage within the meaning of the policy. There have also been other cases. For example, there was a case involving some rocks that were falling on houses, and 3 homeowners sued for physical loss or damage. Only 2 of them had rocks actually hit their house. But the court found that the risk of loss is what the insurance policy was intended to cover. And they found coverage for all 3, even though one had no structural damage to the property. So there are a number of cases out there on these issues. And there are also a number of cases that talk about these civil authority orders. The civil authority orders, as Bob mentioned, are why most people have closed down. And these cases say that the civil authority coverage, in many instances, does not require that you have your property being, any physical loss or damage. If any property in the area within the civil authority is closed down, then there can be coverage under certain situations.
In other words, if, for example, with the fires in Los Angeles, that where there was a risk of fire spreading, and so civil authorities ordered a lot of people to evacuate, business to shut down, even though there wasn't smoke, there wasn't any physical damage or even immediate threat. It was just prophylactic. That would be the kind of thing that would be covered under this particular alternative proposal, alternative provision of the policy, I take it.
I think that's a great analogy. And one of the things you have to look to is the policy language to see how far the civil authority coverage extends. I've seen some that are as little as 1,000 feet and some that are as long as 100 miles.
Interesting. So to remind everybody and the participants, if you would like to pose a question to the panelists, and we have a couple which we're going to get to, pop them in the Q&A at the bottom, or alternatively in the chat. You'll see a little icon down there, and you can click on that, and that'll pop up a chat box. Our first question is a general question, and I'll put it out to all of you. If you are aware of any carrier out there that has paid any business interruption losses as a result of the current pandemic, I think is the implication there. Or get to the broader. Sorry, go ahead.
I'm not aware of any. In fact, it's very, very interesting, Professor, that initially when these claims were being made, they were getting denials instantaneously without any investigation. As soon as we filed our first
I think we just lost Bob in the middle of a sentence. There we are. You're back. Oh, good. We didn't even have time for a commercial interruption there. Sorry.
As soon as we filed our first case, all of a sudden we're getting insurance companies asking tons of questions. They're all represented by major law firms. They're all doing their due diligence before they send their denials, but the specific answer is no one is paid.
Okay. Uyen?
I'm aware of one particular court, but it's not within the United States. It's actually in France, and I think it's within the last couple of months. There was a French court that actually ruled in favor of a restaurant that had made a claim for business interruption losses against its insurer, and the insurer was AXA. And that ruling came out, and so initially I think AXA was going to appeal that ruling, but now they've recently agreed to pay out and also review their other policies for various restaurants in France. But that's just limited to France, and so I don't know what type of effect that will have on courts here in the United States.
Well, interesting. I'm sure that our other panelists representing the plaintiffs will be seeking the the citation for the French case. It's always good to have precedent, even if it's from a non-common law jurisdiction. Of course, as many of you know,
that may be controlling in New Orleans, John.
It might be. There's a very good point. Maybe you want to file another case in New Orleans. There's also a question about generally there isn't a problem with if you did have an all-peril insurance and you did have a fire. And I'll just throw this to you again, Uyen. Carriers that you've represented would pay that kind of a claim because the fire has shut down the business. They can't operate until the fire is cleaned up and so forth. That's not the kind of problem that we're dealing with here.
We've seen scenarios where it's due to civil authority, where it's the local and state governments mandating certain shutdowns or restrictions on businesses and such. So those are more of the typical type of cases. But there are other claims under the regular property insurance claims for damage to, for cleaning and sanitation and those types of expenses. Those can be claims that are made directly under the property insurance coverage directly.
Oh, I see. Okay, not necessarily business interruption. It's just a cost associated with reopening a business. Okay. So there's another question having to do with act of God or act of nature. Does that have any role in this particular kind of litigation? And I'll throw it out to everyone again.
John, I'll say this. I've looked at hundreds of denial letters, and I have not seen that listed as a reason for denial. I mean, I've seen things, pollution exclusions and virus exclusions and all kinds of different reasons, but I have not seen yet act of God raised by the carriers.
Yeah. So, Uyen, there's another question actually directed to you, having to do with how a policyholder could have negotiated language to cover this kind of a pandemic. So you have this dispute. The claimants or policyholders are saying, well, if the insurer wanted to exclude this particular problem, they could have put it in. And the insurer will say, contradictorily, if you wanted it, you could have negotiated for it. So I think that's where this question is coming from. How would a policyholder, could a policyholder have negotiated? We're not able to hear you. Sorry.
Yes, a policyholder or insured could negotiate or request this type of coverage, and it's usually through their brokers. And what they would do is have a rider, which is an endorsement that's added to the policy to have this type of coverage and specifically state out what that coverage would include. So a natural disaster or some other type of event. And you presumably could put in pandemic coverage or global crisis or something like that within the policy. And there are some policies that have that. And I think that's a result of the 2003 SARS outbreak. And so the virus exclusions that we see now is a result of the underwriters writing into the policies those exclusions. And so on the other side of the coin, you can have insureds requesting that coverage to be put back in as a writer or an endorsement for that coverage.
So go ahead.
Professor, let me just jump in here. Mm-hmm. You bring up a very, very interesting point. First of all, it is nearly impossible for a non-lawyer, and maybe most lawyers, to even interpret any of these policies. Some of them run 50, 60, 70 pages. The language is nearly incomprehensible. But there is a duty on the part of the broker to inform their client that, here is things that now are in your policy that you didn't have before. Here is a new exclusion. Do you want to get coverage around this exclusion? Do you want to include new coverage? And so we're looking very closely at broker liability as well as insurance liability.
So let me ask Thomas about a little bit further about this virus exclusion. Exactly, are these policies all saying the same thing? We exclude coverage, and what is the language that excludes coverage for viruses? In other words, if someone is attempting to exclude coverage through this policy provision, exactly what does that policy provision say, and how are they attempting to accomplish that result?
Well, they're across the board. First off, a lot of the policies include virus coverage.
They include it.
There's an inclusion for it.
Okay.
They're denying it anyway. Some policies are vague on it. Some policies exclude it by excluding, normally they'll say microorganism and virus is the language that they use. But what's so interesting in the policies where they exclude it is, how they got there. And Uyen brought up, my friend Uyen brought up the SARS pandemic. And what happened is, after the SARS pandemic, these carriers went to the regulators, because of course insurance is highly regulated, and told them that they were not reducing any coverage and they were putting in these exclusions. What they were really doing was just making it more clear. Mm-hmm. Because had they reduced coverage, they would have had to reduce the premiums that they charge, and they didn't do that. So carriers to regulators all over the United States convinced them that after SARS that they were not limiting coverage. We know that that's not true now that we've had the COVID-19 pandemic. So there's really three scenarios. One that we see very often is when the virus is included, but they're denying it anyway. The second is when it's vague, and the third is when it's excluded. And really, I think it's unfairly excluded because they convinced the regulators they weren't making any changes after SARS, and in fact, there are major changes.
That's very interesting. So at least in California, there was this argument. Is this true elsewhere, or are you referring primarily to discussions in California?
Well, California is 100% true. And then I talked to my friend Rob there, who's been tracking it, every case all across the country, and he's seeing the same thing too. Isn't that true, Rob?
Sure. I mean, these exclusions were peddled by the insurance services offices to the various regulators, sort of using the same spiel. That is, this isn't going to have an impact on premiums because it's not really impacting coverage. When in fact, what they really have was an all-risk policy that they were writing, and now they're excluding pandemic coverage, if you will. And that is an exclusion. That is constricting the coverage that was available under an all-risk policy. And they basically pulled the wool over the eyes of the regulators and got them passed.
Well, I'm sure that'll be an evidentiary question in dealing with this matter going forward. Uyen, this may be a question for you. One of our attendees is asking about the reserves in the insurance industry for these kinds of problems. Are there adequate reserves? Are you familiar with any studies that examined into the reserve question?
I haven't looked into that particularly with respect to the exact amount of reserves and such, but as it stands, the carriers have indicated that they have not received adequate premiums to cover a pandemic loss or business interruption losses for their insureds, and so they are not able to pay out all of these claims if they were to. So there aren't adequate reserves. But what I do see is I think there's been a federal act that was introduced, which is called the Pandemic Risk Insurance Act. And it is similar to the Terrorism Risk Insurance Act, which resulted from the 9/11 terrorist attack. And that's where the government and private companies or the insurance industries collaborated and provide a fund in order to pay out those claims. And so this is a similar type of program that might be federally backstopped to help pay out on those claims, because as it stands now, the carriers will not be able to pay out on all of these claims if they were ordered to by a court or by legislation.
Mm-hmm. So I'm sure we're going to have a lot of, pretty intense litigation around that, especially if it is challenging the financial stability of a company. Bob, are you worried about that? The insurers being inadequately reserved, or and not because they wouldn't have wanted to be, but because they couldn't have anticipated, couldn't have anticipated the vast extent of the loss?
Well, first, I've been informed that Chubb Insurance has put aside $1.5 billion to settle these claims. I don't know about the other companies. The insurance industry as a whole has reserves in excess of $600 billion, which is quite a war chest to go against three little country lawyers here. But
presumably there'll be other ABOTA lawyers and other plaintiffs' lawyers around the country who will be joining you in one court or another.
We're afraid that's going to happen, but we would like to be up and out in front of all of them. California has similar legislation pending that the insurance companies would be reimbursed by the government for losses. So, of course, it's a concern, but I think insurance companies are certainly going to have enough money to come up with settlements that are reasonable and that would be acceptable, especially to our clients.
Yeah, well, since we're speaking generally and not about a specific company here, we don't know about the reinsurance issues and the spreading of risk amongst the insurers. So it's hard to get further into that particular question. But if we were to stay with the litigation issue, every state has some form of MDL, multi-district litigation, and of course there is a federal multi-district litigation. And I take it that your case, the case that you have filed in California, is filed in state court, not federal?
So that's a great question. We're filing all of our cases in state court, generally. The insurance companies are claiming diversity and trying to move them all to federal court. Our class action for plaintiffs under $50,000 was filed in federal court.
Okay, in California?
Yes.
Which district?
Central.
So you want to be in LA if you...
Yes.
Okay.
Preferably.
So if there are cases removed elsewhere to federal court and they involve similar litigation around interpreting policies, even if they're diverse policies, and there could be hundreds of these business interruption policies, as I understand it, there would have to be a question as to whether MDL would be appropriate if there were multiple interpretation.
That's a big concern of ours. Obviously, we would like to have as many individual judges ruling on this rather than one, and rather than one law firm heading a team of lawyers in pursuing these. So that's why we're trying to keep these cases in state court. One way we can keep them in state court is if we find that there is a reasonable liability on the part of the broker, that will change diversity, and we'll be able to keep it in state court.
So you're researching and now trying to determine whether you haven't yet filed against any of the brokers who might be.
That's correct.
Okay. I'm sure that people representing brokers who might be tuned in here are calling their insurance brokers and say, you might need to hear this conversation. You're at the cutting edge of potential litigation as people are trying to figure it out. So you and I understand that there are going to be bills filed in probably every state, if they haven't already been filed, in state legislatures, and you mentioned that Congress may get involved as well. Do you think that the insurers will have a good argument to get these decided in this fashion? Is the legislation promising from your standpoint?
On behalf of the carriers, they are adamantly opposing these bills, and one reason is because these, at the basic core, it's a contract between two private parties, and the carriers would argue that now you're in violation of U.S. Constitution as well as state constitutions that prohibit legislation from overriding private contracts. And so I think the carriers have a strong argument against having these bills enacted.
So there's two different kinds of bills, as from what you're saying, I gather. One bill could be a legislature saying the business interruption provision in a policy does not cover this kind of an event, if they wanted to represent the insurer's interest. And the other kind, of course, would be taking up the cudgel on behalf of policyholders and say, we hold that a legislative opinion or even a statute that says this statute is designed to say that business interruption insurance must be interpreted to cover this kind of a claim. So that would be an argument. The argument would be the second legislation would be retroactive, and because it's retroactive, you have an argument that it is unconstitutional, even though it's often done both in the common law and in legislative enactments relating to torts. That would be the argument, at least, that you would try to be making.
Yes, and so what we've seen so far is that there's about a dozen states that have introduced bills, and these bills vary in terms of what they're providing for in terms of coverage. Some of them state that even if you have a virus exclusion, there is still coverage because the pandemic and coronavirus is considered to be property damage. And then you have some where it states that only if there is no virus exclusion or it's ambiguous, that now there is coverage. And recently, California has amended its bill, and I think it was in June, and it states that there's a rebuttable presumption that the coronavirus is property damage for purposes of coverage under business interruption, and that now it shifts the burden onto the carriers to give them an opportunity to provide scientific evidence to contradict that finding.
Yeah, that's an interesting, did that particular bill pass, and was it signed into law?
No, it's just been introduced.
It's been introduced, I see. One of the interesting questions here, since we're dealing with the potential ambiguity of a policy language, and I'll throw this out to you, Rob. If policy language is ambiguous, is there an interpretive rule that courts have routinely established around how to interpret ambiguous phrases?
Sure. Ambiguities are construed in favor of coverage. Simple insurance law 101.
And that's pretty much true about all kinds of insurance policies, I take it.
Absolutely. And exclusions, ambiguities and exclusions are interpreted such that the exclusion would be inapplicable. So there are certain presumptions, if you will, and that may be, you may correct me on that term, Professor, that go in favor of policyholders. And part of that is because these are adhesion contracts. I mean, these are contracts that are on the forms that the insurance companies have promulgated. And this opportunity for the traditional negotiation of the terms is largely non-existent in most of these.
So the policyholder who's going out to get business interruption insurance is pretty much going to be having to accept. It's very hard to negotiate general language in the policy as you on on a one-on-one basis, unless you're Intel or some huge company, then you can probably get whatever you want for a price,
I mean,
of course.
yeah, it's the equivalent of trying to negotiate with Hertz at the airport on your rental contract. I mean,
Yeah.
it doesn't happen, and,
Yeah.
and the courts know that.
So a couple of the questions that have popped up in the queue. Going back to one of the questions that came up earlier, and I think it was, I forget if it was Bob or Rob, that you said, or one of you said that that carriers were quickly denying that the claim was made and there was an immediate denial. Is that, I forget who said that. Was that you, Rob?
That was Bob, I think, but
Bob,
I still had the same experience.
you had the same experience. Well, let me ask you, Bob, is there any other claim if this is, if there was an immediate denial without an investigation, do you have any other kind of a claim that you could make?
I think potentially you would have a claim against the insurance company for failure to properly investigate the claims. And we haven't really looked at that closely, but that's something we're certainly going to be considering also.
So it'd be a claim, if an insurance company immediately denies without investigation, without further inquiry, the claim would be there's a bad faith, basically a tort claim. It's no longer an interpretation of a policy claim. It's a tort claim, a bad faith insurance claim.
Absolutely.
Yeah. Thomas, are you guys looking into that?
Well, certainly we are. And what's most important for us is to not add burden to our clients. So most of our clients are, major hotel chains, major restaurant chains, and what they're trying to do is get back on the feet so they can make their payroll. So the cases that we're trying to focus on are, more declaratory relief. Put the issue in front of the judge without having to open a lot of discovery against our corporate clients who have their hands full right now. So what's more important to us is to get the major issue in front of the judge, and we can pick up these other issues later. I think how we're looking at it.
Are you taking these cases on a contingency basis? There's another question.
Well, I'm going to turn that over to Bob and see how he feels about responding to that, Bob. That's too hot for me to...
I see. Now we're getting into the internal dynamics here.
We're taking all these cases on a pure contingency basis, investing significant amounts of legal time as well as financial assistance to bring these cases before a jury. Once we get by declaratory relief, the insurance companies will come begging for settlements.
I'm sure that Uyen, you probably have a view of this, and you've represented insurance companies in litigation. Would you, and I don't want to put you on the spot, but do you want to be in front of a jury on these kinds of cases?
Typically, the juries do not like insurance companies. So,
I heaven forfend, I never heard of such a thing. Being a torts professor.
Attorneys in that respect, I suppose. But typically, carriers would not prefer to be in front of them.
Yes, I think that's fair to say, and not because that there isn't a role to play by insurance companies. I probably should note, although I'm a torts professor, my brother was an insurance defense lawyer, so we had our share of discussions around these kinds of issues. So we have just a few minutes left. I want to give everyone on the panel an opportunity to just add anything that they care to. And if anybody else has a question, they want to pop them in the queue, please do so. I see one just popped up, so maybe we get this question and then I'll ask you for final words. There's a question about what about claims against brokers? And I think, Bob, you already referred to this, but brokers told insurers that they were covered or did not discuss possible coverage options. I think the one involving brokers who actually told clients that they were covered for this kind of thing would have a different kind of a problem than those who simply didn't mention it. Would that be fair to say?
I think both would have problems. I mean, if they didn't mention it and there were changes, especially if there was a change in the policy that went from not having the exclusion to having the exclusion and not pointing it out directly, is going to cause a broker liability in our view.
Yeah.
The other one that would be more challenging would be the responsibility of a broker to tell a client, you know, there is a virus exclusion here. People, look at people are talking about this long before it happened. Bill Gates was out in front of this 5 years ago. So these are things that brokers should have brought up to the attention of the insured.
Well, there certainly have been international instances of virus spreading, you know, SARS, and, you know, I think they're trying to change the name of some of these to not be reflective of particular geographical locales. But you had the one rising out of the Middle East, you had the ones that came out of chickens, and, you know, swine flu and so forth. All of these it's not a foreign concept that you might have viruses in the country, I suppose. The question is whether there's an affirmative duty as opposed to, you know, an affirmative duty not to misrepresent, but an affirmative duty to explore, to explain. And I guess that's where you're coming from there.
Yeah, and I think definitely there is such an affirmative duty. I mean, as we said before, these policies are so complicated. I don't know anybody other than an insurance lawyer who would read these policies. You talk to a broker, they send a policy, they send you a bill, and you pay it.
All right. Okay. Go ahead, Thomas.
Well, I think, you know, in these policies where we see where it's excluded, it's hard to see how a broker could not advise a major client about that, particularly after SARS. It's a knowable and foreseeable event. And, you know, the carriers are certainly going to bring that up too and say, well, if your broker wanted you to have that, the broker would have said something. So I think the brokers, what they did and what they didn't do is going to be at the forefront of the litigation.
And that's very interesting. We are running short on time. We try to finish before the flipping over of the hour. So let me give everybody a last word. And Uyen, let's start with you, representing insurance companies mostly. Do you want to have do you have some last comment you'd like to make about these issues? I think you're muted.
Oh, I think most of these issues are going to be resolved through litigation. And so it will be interesting to see what the courts do in the United States. And so the first ruling to come out will probably have some sort of impact on the rest of the cases.
I think I think that's very important. So being first in line, as I think your three cohorts on the panel wanted to be the first case in California. They may very well get that ruling earlier than others. Rob, last words?
Sure. All of these businesses paid premiums and were told that they had business interruption coverage. Their businesses have been interrupted. Now they have an insurance company telling them they don't have coverage. Somebody should have to answer for that. If there is a gap, it's the responsibility of someone, whether that's a broker because indeed the insurance company is right, or whether it's actually there is coverage. These businesses should be taken care of. They paid for this coverage.
All right, Thomas?
I agree with Rob. It's insurance is a special relationship because we're paying for something, a future promise. You pay the premium for a future promise that the carriers will be there when you need them. The event happened and the carriers weren't there at all. That's what this case is about.
Well, you know, I mean, just to add one more thing, it's at least in California, it's considered a near trust relationship, not literally a trustee relationship, but it's a near fiduciary relationship. And 39 other states have found at least some issues of bad faith tort in relation to insurers if they screw up in some fashion. Last word, Bob. I'll give you the last word in terms of this litigation ongoing.
physical loss or damage. That's what this case comes down to. And I don't know any reasonable person who could say, if your business is shut down because of the government, you are not damaged.
Very good. So we'll stop there. I know there may be other questions in the panelist, for the panelists, and I think all of you would be willing to respond further, perhaps to emails, which should be available on your website. So I want to again thank you all. Rob, thanks for tuning in from Houston. Thomas, and Thomas was behind the organizing of this, which we really, really appreciate. Uyen, thank you for stepping in and holding down the insurer's point of view. We really appreciate that. And Bob, as always, it's great to see you. Thank you all very much.
Most importantly, thank you. You did a great job.
Thank you very much.